Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, if you're enjoying our legal education content, please remember to hit that notification bell, select that all option so you can get alerts of all of our uploads and our live streams, such as this one. For tonight's live stream, we are covering a decision from the Fourth Circuit Court of Appeals. That's in Richmond. And rules that 18-year-olds might have the right to have firearms. Okay. So that's a thing that happened. Somewhat unexpectedly. I say unexpectedly because the Fourth Circuit has not been particularly friendly on firearms rights in cases as of late. Not that any of the circuits have been particularly friendly. And, you just would imagine the court to just say the words intermediate scrutiny over and over again, like some sort of chant or some sort of shibboleth or something. Intermediate scrutiny, intermediate scrutiny, intermediate scrutiny. But that didn't happen. They actually said, maybe 18-year-old to 21-year-olds might have a right to a gun. Interesting concepts. Okay. So that happened. So we're going to read this decision and see what it has to teach us. So that'll be fun. This is the Fourth Circuit Court of Appeals Federal, so that is Virginia, Maryland, and some other states. Let's cover this. Where is my thing? No. Yep. No. Great. All right, great. Okie doke. Let's cover this thing. Oh yeah, and before we get too excited, I will just remind you of some things. Just remind you that of course you can appeal from the Fourth Circuit both to itself in the form of an en banc and to the US Supreme Court. And the Fourth Circuit, last time I checked, the majority was more left-leaning. So the odds of this case being long for this world and not being overturned by the Fourth Circuit en banc, But we'll enjoy it while it lasts, I guess. When do constitutional rights vest? That's a good question. At 18 or 21? 16 or 25? Why not 13 or 33? In the law, a line must sometimes be drawn. Yeah. But there must be a reason why constitutional rights cannot be enjoyed until a certain age. This reminds me a little bit of Tinker, right? Because the Tinker versus Des Moines with the black armbands in the schoolhouse. You don't shed your rights at the schoolhouse gates implies you have rights before you get to the schoolhouse gates, which is also, of course, recently reaffirmed in Mahoney versus BL. So children have constitutional rights too. They might be different in some ways, but that doesn't necessarily imply they don't exist. Our nation's rights vest no later than 18. And the Second Amendment right to keep and bear arms is no different. Okay. That would certainly be consistent with the rest of our Bill of Rights and the rest of our understanding of it. We certainly don't treat the First Amendment or Fourth Amendment or the Sixth Amendment, or really any of the amendments differently between 18 and 21. So it would be a little odd to treat the Second Amendment differently than all these other rights. Plaintiffs seek an injunction and declaratory judgment that several federal laws and regulations that prevent federally licensed gun dealers from selling handguns to anyone 18, 19, or 20 violates the Second Amendment. This is such a weird thing, too. Because it's not illegal for an 18, 19, or 20-year-old to possess a handgun. It might be in some states. We're talking federal law. So it's not illegal to possess it, but it's illegal to buy it. Which is a very odd thing when you stop and think about it. We first find that 18-year-olds possess Second Amendment rights. Maybe like the First Amendment or Fourth Amendment. They enjoy almost every other constitutional right and were required at the time of the founding to serve in the militia and furnish their own weapons. That's true. The 1792 Militia Act? Or was it 1793? One of the two. 1792 or 1793 Militia Act said 18-year-olds were part of the unregulated militia. All of them. We then, or was it 1794? Somewhere in that. We then ask, as our precedent requires, whether the government has met its burden to justify the infringement of those rights under the appropriate level of scrutiny. And this is normally the part where you just chant intermediate scrutiny over and over again until the case goes away. To justify the restriction, Congress used disproportionate crime rates to craft overly inclusive laws that restrict the rights of overwhelmingly law-abiding citizens. And in doing so, Congress focused on the purchase from licensed dealers, again, because it's not illegal to possess, without establishing those dealers as the source of the guns used to commit crimes. And also, as I mentioned, it's legal to possess, but not legal to buy. So we hold challenge federal laws and regulations are unconstitutional under the Second Amendment. Despite the weighty interest in reducing crime and violence, we refuse to relegate either the Second Amendment or 18 to 20-year-olds to second-class status. I like that very much. We refuse to relegate the Second Amendment to second-class status or the 18 to 20-year-olds to second-class status. This pleases me. $5 from their 51 to another. Thank you for the super chat. Prospective handgun buyers sued the Bureau of Alcohol, Tobacco, Firearms, and Explosives, seeking an injunction and declaratory judgment that federal statutes prohibiting FFLs from selling handguns and handgun ammunition to 18, 19, 20-year-olds. Yeah, and then you get into that wonderful question about what is handgun ammunition. I totally forget the regulations on this. Completely. I honestly don't know at all anymore what handgun ammunition is. The reason I say that is because there's carbines. You can shoot handgun rounds out of a rifle. So, I forget. 19-year-old Natala Marshall had a good reason to seek protection. She had been forced to obtain a protective order, which I'm sure will protect her. The protective order will save her, don't you know? Against an abusive ex-boyfriend who, since the issuance of the order, has been arrested for unlawful possession of a firearm and controlled substances. No. He was released on bail, but never came to court, leading to the issuance of an arrest warrant. Along with the threat from her ex-boyfriend, Marshall works as an equestrian trainer, often finding herself in remote rural areas where she interacts with unfamiliar people. Having grown up training with guns, rural, sure, she believes that a handgun, ease of carrying, training, and use makes it an effective tool for her protection. But because Marshall is 18, not so much. She can't buy it from an FFL. She preferred using an FFL because they have a wider supply, good reputation, and a guarantee that the guns have not been used, stolen, or tampered with. I'm not so sure about all those factors, but, it's definitely a higher likelihood. She's 19, and she remains unable to buy a handgun from an FFL. The other plaintiff, Tanner Hirschfield, tried to buy a handgun from a licensed dealer and was denied because he was 20. But he's 21. His claims are therefore moot. Marshall, however, is not 21 yet, so this appeal may still proceed. I'm not sure that the 21 thing necessarily applies because it's constant of repetition and so forth and so on, but whatever. We at least have one person outstanding. In 1964, Congress, concerned about increased gun violence, began a field investigation in public hearings. Congress concluded, among other things, the ease at which handguns could be acquired by juveniles without knowledge or consent of their parents or guardians, which, 18, is a significant factor in the prevalence of lawlessness and violent crime. Statistics, testimony from law enforcement, and other evidence showed a large portion of violent crime and escalation stemmed from minors with guns. I'm not necessarily sure the minors with guns is necessarily the principal problem here. Maybe it has something to do with gang activity. Based on the testimony from the Internal Revenue Service, Okay? Congress concluded juveniles obtain these guns from licensed dealers who sell to emotionally immature or thrill-bent juveniles. I'm not sure how the IRS got into this, but okay. They also found that handgun is a type of firearm that's principally used for the commission of serious crime. That's true. And the most troublesome and difficult factor in the unlawful use of firearms. Seeking only to curtail clandestine purchase of weapons, which we're going to prevent the clandestine purchase by preventing them from going to a licensed dealer. Okay. Seeking to curtail the clandestine purchase by forcing them into less regulated channels. Congress sought to permit the ownership of use without parental permission, which is still not illegal because possession's not illegal. You just can't buy them from an FFL. To address these concerns, Congress passed the Omnibus Crime Control and Safe Streets Act of 1968, otherwise known as the Gun Control Act of 1968. The preamble declares the following: the ease with which any person can acquire firearms other than a rifle or shotgun, which also is not illegal for an 18-year-old to buy a rifle or shotgun from an FFL, including criminals, juveniles without the knowledge or consent of their parents and guardians, narcotic addicts, which incidentally, it's illegal for narcotic addicts to buy guns because they're addicted to a controlled substance. Well, actually, strike that. Not that they're addicted to a controlled substance, they're a user of a controlled substance. Mental defectives, armed groups who would supplant the function of duly construed public authorities, and others whose possession of weapons is similarly contrary to the public interest, is a significant factor in the prevalence of this lawlessness. The Act prohibited licensed dealers from selling handguns to anyone under the age of 21, but permits rifles and shotguns without parental knowledge. Later that year, Congress amended the law to prohibit licensed dealers from selling any firearm to those under 18 and maintain the ban of handguns for 18, 19, and 20. The section, which is unchanged since 1968, reads as follows: it is unlawful for a licensed importer, licensed manufacturer, licensed dealer, licensed collector, licensed to sell or deliver any firearm or ammunition to any individual who the licensee knows or has reasonable cause to believe is less than 18, and the firearm or ammo is other than shotgun or rifle, or ammo for shotgun or rifle to any individual who the licensee knows or has reasonable cause to believe is less than 21. You see how the word licensee comes up a lot in the statute, right? The licensee is prohibited from doing these things. That would be the FFLs that we've been talking about, right? So the FFLs are federal firearms licensed dealers, right? They're the ones that do the background checks and so forth and so on. And in order to prohibit 18-year-olds, 19-year-olds, and 20-year-olds from acquiring handguns, we're going to prohibit only the licensees, the most regulated source, from selling or transferring to an 18-year-old. Now, if you're not a licensed dealer, go nuts. So we only have problems with the 18, 19, and 20-year-olds obtaining a firearm if they're obtaining it from the most licensed, regulated source possible. As long as it's an unregulated source, we're cool. Okay, that's an interesting choice, Congress, on that one. The implementing regulation contains singular language. The law did not eliminate any other age group's ability to own, possess, or use a gun. Along with the part of the law requires licensed dealers to obtain a sworn statement of age and other things, and regulations promulgated by the Bureau of ATF required licensed dealers to keep firearms transaction records, the 4473, for some period of time, which I forget how long that is, but it's a long time. I think it's like 20 or 25 years. It's been a while since I checked. It's a while. The upshot of these statutes and regulations is the 18, 19, and 20-year-old may not buy handguns or ammunition from a licensed dealer. Unlicensed dealer, though, totally cool. Your friend on the street corner, totally fine. We want to specifically prohibit you from buying it from someone who has the ability to conduct a background check and can make you file sworn statements and can verify your identity. But friend on street, totally fine. Yeah. $5 from Mandalore Y01. We all know the boys in Detroit don't care about licenses. Yeah. Nor do they have to, because the regulation by its own terms doesn't cover those. The upshot of it is the 18, 19-year-olds, 20-year-olds, not so much from the FFLs. Plaintiffs challenge the facial validity. So we're challenging it globally to everybody instead of just me. And regulations restricting the ability to buy handguns and ammunition from an FFL. For relief, they seek a broad declaration that this violates the Second Amendment. The government moves to dismiss for failure to state a claim, which, reasonable, unfortunately, because the state of the law before this moment, right? And plaintiffs move to summary judgment. Which, there's no reason not to move to summary judgment. There's no facts in dispute, right? It's a straight question of law. We want to buy guns, they won't let us. There are no facts in dispute. So it's a straight question of law. Great. The district court held the laws were facially valid because they're among long-standing prohibitions and conditions and qualifications of commercial sale of arms, which the Supreme Court in Heller did not cast doubt on. Yeah. The court also found the laws fell outside the scope of the Second Amendment because similar regulations were historically common among the states. In the alternative, the court relied on the legislative record and some of amici's evidence to find the laws past intermediate scrutiny. This is the part where the chant just comes in over and over again. Intermediate scrutiny, intermediate scrutiny. So the court denied plaintiff's motion for summary judgment and dismissed and appealed, which unfortunately was a perfectly reasonable decision for the district court to make because of the state of the law before this moment. We have subject matter jurisdiction. The denial of it is de novo because all there are in place is legal issues. The Second Amendment provides a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. This inherent, fundamental, pre-existing right is not limited to militia. See Heller, which used all those words. It's a personal, inherent, individual, fundamental, pre-existing right. All these words. Its core, because the Second Amendment, like every rights, might have different things at different scopes and different ambits. We could go over First Amendment law in excruciating detail. So the Second Amendment might have some sort of similar framework. But if that's true, there's still some core at it, right? So the core is the right of the law-abiding responsible citizen to use arms in defense of health, hearth, and home. Heller. Heller strikes down the handgun ban and law requiring guns to be unloaded and locked within the home as violating the core of the Second Amendment. The court made clear the rights protected are not unlimited, which is true, and so it's true enough. But to say it's not unlimited doesn't mean all the limits, which seems to be what the courts of appeal have generally been doing. The courts say, hey, the right isn't unlimited. So therefore, all the limits. It's not quite what I think the Heller court had in mind. Heller did not cast doubt on presumptively lawful regulatory measures, such as long-standing prohibitions by felons and the mentally ill law preventing carrying of firearms in sensitive places, which incidentally, again, by its own logic, right? If the law prohibits carrying firearms in sensitive places, that implies there's such a thing as a non-sensitive place. Tell that to the courts of appeal, right? Or imposing qualifications on commercial sale of arms. Several years later, the court struck down this handgun ban in Chicago, holding it to be incorporated. It explained that while the original understanding of the Second Amendment focused on an oppressing tyrannical federal government with a standing army, this fear dissipated. Instead, around the time of Civil War, Congress repeatedly voiced concerns Southern states were disarming abolitionists and freed slaves to harass and harm them. Yes, this is where we get into some of the uncomfortable truth regarding some of the history regarding gun control. The historical record seems to suggest that some of the regulations relating around firearms may have had some racist origins. These concerns permeated drafting and ratification of the 14th Amendment, which then in Cruikshank the Supreme Court ignored because it couldn't bear the conclusion that maybe the freed slaves have rights. Reviewing the history, the court held it's clear the framers and ratifier of the 14th Amendment counted the right to keep and bear arms among those fundamental rights. They sure did, which is one of the reasons the Supreme Court in Slaughterhouse and Cruikshank, and until 1930, what was it for until really Whitney versus California, which I think is 1939, and even then it wasn't a majority opinion. Kind of ignored the entire Bill of Rights. But the court has cautioned it has not undertaken an exhaustive historical analysis of the full scope of the Second Amendment. Fair. As a result, many questions remain, including what frameworks courts should use to analyze Second Amendment claims. To fill in the gaps, most circuits seem to follow some version of a two-part inquiry. Well, I would say let's borrow from the First Amendment, right? We have got all this wonderful framework in the First Amendment we could borrow and map. It wouldn't be perfect, but, that's what I think. But here's what the courts have been doing, because they haven't been doing that. The first step asks whether the challenge law imposes a burden on conduct falling within the scope of the Second Amendment. It's a good place to start, I guess. This historical inquiry seeks to determine whether the conduct at issue was understood to be within the scope of the right. Fair. The government bears the burden of showing it's not covered by the Second Amendment. Unfortunately, that burden seems to be somewhat easily met. If the record is silent or ambiguous, we assume the conduct is protected. In theory, if, however, challenge law does not impose a burden, that's the end of the inquiry, which I suppose fair enough in principle, because if it's not within the scope of the Second Amendment, then the Second Amendment doesn't speak to it. Much like saying it's not within the scope of the First Amendment, so the First Amendment doesn't speak to it, so we can stop asking questions. In principle. If the challenge law burns Second Amendment, we move to the second step, for the applying the appropriate form of scrutiny, which is inevitably intermediate, and the way we apply that is a little bit more slipshod than might be ideal. Without articulating the applicable standard for Second Amendment, the Supreme Court found Heller would fail any level of scrutiny. They sure did. They didn't even say it needed a level of scrutiny because it would fail any of them. It offered some guidance, however, in directing a rational basis. So at least some form of heightened scrutiny must be employed. To determine which of this applies, the Fourth Circuit has learned to look to the First Amendment, which is a reasonable place to go. That's where I would go. The way I would do this looks quite a bit different. than the Second Circuit. So it's funny to me because they're saying all the right things in principle. All right, this is kind of like, this is what I think in principle, right? Let's figure out if it's within the scope of the right. If it is, what level of scrutiny, what can we borrow from to help inform that? The First Amendment's a pretty good place to go, right? So this analysis tracks my analysis. The way it actually applies in practice, though, doesn't really seem to work out with the theory. If they actually applied the theory, I'd be less grumpy. And so would you. But we're grumpy because, The Second Amendment's core protection is the right of a law-abiding responsible citizen to use defense of hearth and home. When this right is severely burdened, we apply a demanding strict scrutiny test, which requires the government to show it's narrowly tailored, which is basically impossible, which is one of the reasons they never do it. But the right is burdened only at the margins, and again, in principle, yes. In principle, yes. But much like the margins on a sheet of paper, right? To say, okay, we care about what's at the margins less than we care about the text. If you shrink the margins, or you expand the margins, I guess, as it were, you expand the margins, so it basically is all margin, right? So in principle, yes, but the applied... $5 for Mandalore Wise. Gotta say, Barnes' distaste of lower level scrutiny seems to be rubbing off of me with what excess intermediate scrutiny. Yeah, it wouldn't be so bad if they just actually applied it properly. But the courts of appeal collectively have been going guns bad. Intermediate scrutiny. It's kind of been brainless. I'm not sure the problem is the standard. The problem is they're not really applying it, in my humble judgment. If intermediate scrutiny in the Second Amendment has been described as requiring a reasonable fit, which is the wrong word, definitely. It's not reasonable. That's just wrong. You would want a tighter fit than reasonable. And a substantial governmental objective. You want a substantial interest and least restrictive means. Okay. So we have misstated the standard. That's great. Our inquiry into challenge provisions, facially valid challenges, however, if we find them to be presumptively valid, based on a list of presumptively lawful measures. This list includes long-standing prohibitions on firearms by felons and the mentally ill, laws forbidding carrying of firearms in sensitive places, which, again, implies there is such a thing as a non-sensitive place, and laws imposing conditions and qualifications on commercial sale. If law fits within this test, we can conduct a more streamlined analysis. This often effectively ends the inquiry, very effectively, I would say, and upholds the law as facially valid, but not always. So before turning to the full two-parts test, we begin with the presumptively lawful. Okay, let's do that. The government and amici argue that challenge laws fall into two categories on the presumptively lawful list: conditions on commercial sales and long-standing regulations. First, these laws are not conditions and qualifications on commercial sale. Yeah, it's not a condition and qualification so much as a ban, which is not the same thing, one would think. A condition or qualification is a hoop someone must jump through to sell a gun. Here, though, the restrictions operate as a total ban on buying, which isn't a condition so much as no. There's nothing a law-abiding 18 and 20-year-old can do to buy that except wait till they're 21. The amici compare this to our precedent. There we have upheld a regulation requiring those who sell firearms to obtain a license. The law regulated only those who want to sell guns commercially, but placed no restrictions on those seeking to buy. We describe the licensing law as a condition on sale that affects only those who regularly sell firearms not owned for personal use in the course of trade or business, which seems probably pretty reasonable in the gross, because you can generally license businesses in general. All right, You can require, like, the newspaper publisher to have a license and the newsstand to have a license and so forth and so on, right? You can set regulations. Now, those regulations have to be generally applicable. But, So the idea of licensing people who want to sell commercially, yeah, okay. That seems fine. $5 from TurningNet, who says, seems like they got the law completely backwards based on their own argument. And that should ban third-party sales to 18 to 20-year-olds. Right? I mean, that would seem to be the logic of it, right? If we're concerned with 18 to 20-year-olds getting firearms, let's only ban it going through licensed channels. I don't know about that one. The prior law recognizes a law substance, not form, determines whether it qualifies. As is true in law generally, we don't really look to what the label says, we look to what it is. We cited a district court case for an example of law that would be so prohibitive as to turn a qualification into a prohibition. Yes, because you can regulate commercial entities in general doesn't necessarily mean all regulations are valid. Similarly, in a prior case, the Seventh Circuit struck down a ban on firing ranges within the city because it's not really merely regulatory, but a serious encroachment on prohibiting law-abiding citizens from engaging in target practice in the controlled environment of firing range. It probably is good for people who have firearms to have more training. So let's ban firing ranges. Okay. The nature of these functional bans is highlighted by Heller, where the court struck down a handgun possession and law requiring legally held guns to be unloaded and locked within the home. Did it also require them to be disassembled? I can't remember, but either way. As to the handgun, I think it required the rifles to be disassembled. Not sure about the handguns. As to the handgun ban, the court explained the American people have considered the handgun to be a quintessential self-defense weapon and concluded the ban amounted to a prohibition on an entire class of arms. The court discussed how law requiring legally held guns to be unloaded and locked within a home amounted to a meaningless firearm possession because it made it impossible for it to be used for the core purpose, which is defend of hearth and home. Yeah, if it's unloaded, locked, disassembled, makes it a little bit difficult to use if the need arises. While theoretically possible, reality not so much. Here, the substance of the law dictates their functionally prohibitions, not mere qualifications. They ban an entire group of adults, law-abiding citizens, from the purchase of these guns, substantially burdening these rights. The category of conditions and qualifications referenced in Heller references conditions placed on the selling, like licensing, hours of operation, paperwork requirements, how the items need to be stored at the end of the day, so forth and so on. It doesn't encompass a ban on people seeking to purchase. The dissent argues any restriction on a buyer is also a restriction on seller. In some senses, I suppose, yes, but yeah. No doubt a restriction on buyers indirectly affects sellers, but that can't be enough. If that was enough, then a ban on possession by 18 to 20-year-olds could qualify for this exception, since that restriction on buyers also implicates the commercial sale. That's exactly what the dissent thinks, apparently. In fact, the ban on Heller could be justified by blurring this divide. Right. So it's not that we're prohibiting you from... How do you reframe it, right? It's not that we're prohibiting you from buying it. We're prohibiting it from... You can make it work. By the sense reading, the exception functionally swallows the Second Amendment. Yeah, that's kind of the way the courts of appeal generally have been going. Moreover, the restrictions falls asymmetrically on buyers. Yeah, I mean, if you're trying to figure out who it impacts more, it's got to be the buyers, since they can't buy. While a licensing regime place burdens on sellers with indirect effects on buyers, the restrictions here fall on buyers and operate as a functional bans. Under the laws, sellers lose a subset of customers, but they still may sell to anyone above the age of 20. Those in the restricted age can do nothing. And other options are not always readily available. Going to one of those gun shows I hear so much about, maybe. Not all young adults have friends or family who are willing to gift them a gun, and secondary markets are not always available or easy to navigate. On the other hand, licensed dealers come with assurances of quality, safety, legality, and more. These laws push young adults to be less safe, less regulated market. I know, right? This is like the most perverse of perverse consequences. You want to specifically prohibit them from buying from the licensed, regulated dealers who are the only ones, incidentally, who can conduct a background check. They're the only ones who have access to the system and must conduct a background check for every firearms transfer by law and can look at the person and all the rest of it. And you want to specifically take them from this highly regulated channel to a less regulated channel. Not to mention these restrictions apply to ammo. So severity and difference in burden shows why the laws at issue operate as a ban rather than as a condition. Second, some courts have found the laws presumptively valid because similar regulations could be described as longstanding. The government and amici argue age restrictions for purchasing guns are longstanding because many states have similar laws in the late 19th and early 20th century. Incidentally, I have a general inquiry for the chat. I made some adjustments to my camera. Is the image any sharper? Or is there any more detail in my face than there normally is? I'm just curious. Because I made changes to the setting, and I want to know if it made any difference. So, compared to like the stream I did yesterday, for example. Is this any better? Let's see. The Historical, Textual, and Structural Analysis counsels against creating freestanding categories of law exempt from the Second Amendment. The laws are therefore not presumptively lawful either as commercial conditions or longstanding laws. At step 1 of the inquiry, we asked whether the conduct at issue was understood to be within the scope of the right at the time of ratification. True. The government bears the burden to show that regulation clearly falls outside the scope of the Second Amendment. In the face of historical silence or ambiguity, we assume the conduct is productive. At the very least, this inquiry requires us to consider text, structure, history, and practice to reveal the original public meaning of the Second Amendment. That's a good place to go. That's a good place to go. The relevant question is, what did the right to keep and bear arms mean at the time of ratification? That's an outstanding question. That's an outstanding question. When evaluating the original understanding of the Second Amendment, 1791, the year of ratification, is the critical year. Sources near the time of ratification help us understand the original meaning. These sources shed light on how language was understood and how similar laws were read. Because language, laws, cases, treatises, practice, and understandings change over time, the light provides dims as we move further from ratification. Yes, so if you're trying to figure out what it means at the time of ratification, as you get more contemporaneous, yeah. One relevant source is state law, as various state statutes and constitutions illuminate. Indeed, the definitions and interpretive tools would have been used to understand the language of state laws would also have been used by the public to understand the Constitution. State laws have proved especially helpful in determining who the public would have considered to be included in the militia. This is especially true of ratification, as organized militias were creatures of state law. In 1788, however, the Constitution granted the federal government the power to call forth the militia and provide for arming the militia. And the Supreme Court has held that state militia laws were preempted to the extent they conflicted with federal law. So after 1788, federal law became more relevant to understanding the meaning of the term militia. This is not to suggest state militias have become irrelevant, as the Constitution recognizes important roles for the states in governing and defining their own militias. Indeed, besides appointing officers, the states could pass laws governing their militias to the extent they did not conflict with federal law and can freely control their militias when they were not called forth on the federal government. Yeah. And the public would be most familiar with composition of their own state militia. So both federal and state laws inform linguistic meaning of the militia near the time of ratification. But state laws are less illuminating the further one moves from ratification. This is in part because the states initially were not restricted by the Bill of Rights. As time passes, states may diverge from a common understanding experiment and language is likely to evolve. The Heller Court recognized this as it looks to state constitution laws at the time of the ratification, but noticed that post-Civil War sources are not as insightful. The Supreme Court has made clear Heller relies on 19th century sources as mere confirmation. Right, because it's getting a little bit not contemporaneous. To the extent latter sources are conflicted, their relevance is limited. Evidence about ratification of the 14th Amendment also highlights the waning usefulness of state laws. While founders sought to oppose a tyrannical federal government, the defense of free blacks was central to the passage of the 14th Amendment. Yep. And McDonald's reviewed pre- and post-Civil War laws to show a right of self-defense was part of that right that was intended to be incorporated. In doing so, the Supreme Court review focused on federal laws, such as the Freedmen's Bureau of 1866, and debates in Congress. Many of those debates focused on legislature's alarm about Southern laws and militias being employed to disarm freed slaves. The ineffectiveness of federal law at preventing Southern states from disarming free people motivated Congress to enact the 14th Amendment to stop states from violating the rights to keep and bear arms. So we should hesitate to look to Civil War era state laws that restricted this right as evidence of the scope of the Second Amendment. Yeah, that's a pretty good point. We probably don't want to look to the laws the states were passing to try to thwart the 14th Amendment as being informative of either the 14th Amendment or by implication the Second Amendment. Yeah. Fair enough. Looking through the historical lens to text and structure of the Constitution reveals 18 and 20-year-olds have Second Amendment rights. Virtually every other right applies whatever the age. The Second Amendment is no different. The militia laws in force at time of ratification uniformly requires those 18 and older to join militia and bring their own arms. While some historical restrictions existed, none supports the proposition that 18-year-olds lack Second Amendment rights. So again, in the same way that we can start to talk about finer points, right? To say the Second Amendment isn't unlimited isn't to imply all the limits. To say that there are some restrictions isn't to imply all the restrictions. And so forth and so on. So to say that there might be laws that are relevant in understanding the proper interpretation of the right to keep and bear arms, the pre-existing right, and what it does and does not include from a historical perspective, right? So when we're starting to try to really answer those questions, that's one thing. But we can't go with the proposition, there are some exceptions, therefore all the exceptions. Any more than we can do that in the First Amendment domain. It would be equally dumb. Excuse me. As with any matter of constitutional interpretation, our inquiry begins with the text of the Constitution. Good place to start. Both the text and structure of the Second Amendment, along with its place in the Constitution, reveals it protects 18 to 20-year-olds. First, nothing in the text of the Second Amendment limits age. Second, the most analogous right to the Second Amendment, those in the First and Fourth Amendment. I'm not sure I agree the Fourth Amendment is particularly analogous. The First is much closer to my mind. By a lot. Similarly, contains no age limit. Third, most constitutional rights are not age limited. Fourth, few rights that may not apply to those under 18 or changed by age are not analogous to the Second Amendment. And most of those rights become applicable at age 18, not 21. As the first point, while various parts of the Constitution include age requirements, the Second Amendment does not. The founders set age requirements for Congress and the presidency, but did not require any age limits to protect Bill of Rights to certain ages. In other words, founders considered age and knew how to set age requirements, but placed no restrictions on these rights. Turning to the second point, the two rights most similar to the Second Amendment apply to people regardless of age. The Second Amendment refers to the right of the people, which is also the phrase used in the First and Fourth Amendments, to denote an individual right. It sure does. Like the Second Amendment, both the First and Fourth codify pre-existing fundamental inalienable individual rights. That's kind of true of all the Constitution, isn't it? Well, maybe not so much on the Third Amendment. So let's see. The First Amendment does, Second Amendment does, Third Amendment does, Fourth Amendment does, Fifth Amendment. I don't know eminent domain well enough off the top of my head, but the rest of it does. Sixth Amendment does, Seventh Amendment, jury trials, Eighth Amendment, cruel and unusual certainly does. Yeah. So I'm pretty sure most of it is pre-existing. I'm not so sure about the eminent domain one. I'm pretty sure the quartering wasn't pre-existing. That was kind of the problem. But other than that, yeah. Okay. The Supreme Court and the Fourth Circuit have used the First Amendment as a guidepost. It's a great place to go. Wish we took it a little bit more seriously. The First Amendment applies to all persons, either those under age 18, citing Tinker, which I mentioned at the top of the stream. To be sure, minors' First Amendment rights are qualified to some degree, which is kind of true in general of everything and also because of the place. But those qualifiers do not limit the rights altogether, for time, place, manner restrictions are part of everyone's First Amendment. Well, it's nice that I got there half a sentence before the court did, right? It's always validating when I say something and the court says the exact same thing half a sentence later. It's like, yeah, well, it restricts the child's rights. Well, I'm like, yeah, but that's because of the place restriction. Then it says, oh, time, place, manner restrictions. It's like, yeah, that's what I just said. I got there first. Instead, Tinker presumes minors to have similar rights as adults because they do not shed their rights at the schoolhouse gate. The logic of Tinker has been applied in the Fourth Amendment context. It's indisputable the Fourth Amendment applies to the rights of all persons, including minors. But like the First Amendment, the context matters. The existence of the right, however, is not limited to age. The Ninth Amendment doesn't codify a pre-existing right. The Ninth Amendment just says that, well, I guess it depends how you understand the Ninth. The Ninth says there are rights that we didn't mention. I'm not sure that's exactly the same thing as codifying it. And if it is, it's very ambiguous. So, I guess fair. Yeah, okay, maybe the Ninth too. To be clear, in considering analogous rights to the First and Fourth Amendments and their applicability to minors, we're not suggesting protections of the Second Amendment necessarily extend in full force to those under age 18. Nor do we suggest minors have unfettered rights to purchase firearms. We merely emphasize the First and Fourth Amendment's protection of the people, including those under age of 18, confirms the people protected, includes those at least 18 and older. Yeah. Yeah, that's fair. As for the third point, less analogous rights, such as enumerated rights, due process, and equal protection, apply to all persons, including minors. Newer unenumerated rights do as well, citing Planned Parenthood. The Fourth Circuit calls it an unenumerated right. They also call it a newer right. I'm not sure if that's a burn or not, but I'm interpreting it that way. While the Eighth Amendment applies differently based on age, it does so by providing greater protection to those under 18. The Supreme Court has held the Eighth Amendment's application to minors prohibits the use of death penalty to those under the age of 18. The court drew the line at that age and is held to it. For the age of 18 is the point at which society draws the line for many purposes between childhood and adulthood. It is the age at which the line for death penalty eligibility ought to rest. And the arguments between Scalia and Breyer, I think at University of Arizona on this were very good. Since Roper, no federal court has expanded this logic to provide greater protection to those over 18. No federal court has held that one ever loses protection under the Eighth Amendment or somehow escapes it by reaching the age of majority. Finally, there are some rights that do not apply to those under 18. But those rights also suggest 18-year-olds are protected by the Second Amendment because the court has drawn the line for their application at 18. The jury trial right does not apply to juvenile proceedings. But many state laws end jurisdiction of juvenile courts at age 18, with fewer at age 16 and just one at the age of 18. I'm honestly not familiar with that case, McKeever versus Pennsylvania. I knew the rule, but I'm not sure I've ever read that case, so maybe someday I'll have to read that one. Many view the protection of juvenile proceedings for minors as better and want to increase the age at which they apply. Yeah. The other relevant right is voting, which is explicitly limited to those of 18 and older. There are only two unenumerated rights that may restrict those for a certain age: marriage and sex. Interesting. I've never really thought about that before. Yeah, if you accept the premise that there's a right to get married, which seems to be correct, then the question might be, from a constitutional perspective, what age does that right acquire at? I never really thought about it before. Interesting. I don't know. The oldest state imposed age of consent is 18. So even those rights apply to some degree to 18, 19, 20-year-olds. But whatever the import, the treatment of these rights cannot overcome strong evidence the Second Amendment vests at least age 18. Indeed, it'd be odd to treat the Second Amendment like marriage and sex, rather than contemporaneously ratified rights like the First and Fourth Amendments. Fair enough. There are many things that minors and even those under the age of 21 cannot do. But none of these restrictions implicate constitutional rights. So states have greater leeway to regulate those activities under general police powers. And while the court has recognized the state has somewhat broader authority to regulate activities of children than adults, that does not mean the children necessarily have different rights than adults. Often they have the same rights, but the interest is different. So that makes sense. It's not that their right is different, it's just the factual analysis comes out differently. That's probably a much better way to think about it. It's hard to conclude 18, 20-year-olds have no Second Amendment rights when almost every other right affords them protection. This conclusion becomes inescapable when we consider the history. The historical evidence from the founding shows 18 to 20-year-olds are protected by the Second Amendment. Founding-era militia laws provide powerful historical evidence. Near the time of ratification, the federal government in every state required 18-year-old men to be part of the militia. This evidences the founding's understanding that militia encompassed the 18-year-olds. The founding-era militia laws illuminate broader individual right enshrined by the Second Amendment. The phrase, a well-regulated militia being necessary to the security of a free state, augments the right of the people and helps us to resolve its scope and ambiguities. The civic purpose of providing our nation's security sits at the Second Amendment's core. Being part of the militia, having a firearm, being prepared for actions were those vital to protecting the Republic. The civic purpose addressed by internal threats because there was no police force. So members of the militia serve various law enforcement functions, including protection against private thugs, such as pirates and renegade Indians, as well as more organized threats. For this reason, many states require citizens to be armed and kept firearms at home, even outside militia service. And there's a footnote citing some stuff. Records of Georgia for the idea some states require citizens to take guns to church, which I think was also a law in South Carolina. New Jersey requiring individuals to keep firearms in their home. That was a long time ago. South Carolina requiring guns at church. See, again, it's nice when I get there. It's nice when I get there before the court, right? I read that. I'm like, I thought that was true of South Carolina. And then it says, oh, that's true of South Carolina. It feels validating to know things. Indeed, the practice have deep roots in the common law. Doctrine of hue and cry and posse comitatus, where privately armed citizens will be called to respond to crimes or other public emergencies. Oh, Levi Bolt, points out that the national drinking age of 21 is a violation of the 21st Amendment. It's not, because strictly speaking, there's not a national drinking age of 21. The federal government is bribing all the states into the drinking age of 21. There's strictly speaking no federal law that requires the drinking age of 21. It's just, if you have it less than 21, we're going to take away, I forget what the percentage is. I think it's 10, it might be 20, I think it's 10. 10% of your federal highway money. And all the states go, yay, money. But yeah, it's strictly speaking, yeah, okay, never mind. Mandalore Y01 says that's a lot of footnotes. It sure is. Militias were also important to repeal invasions while reducing the need for standing army fear at the time of founding. The Federalists. The third part of the militia is closely related to act as a check on tyrannical government. Yeah, that's right. Defense of oneself, defense of the state, defense from the state. Many feared standing army would be used to disarm and oppress people. Why ever would they think that? The militia democratized self-defense and gave the people an important check and voice in governmental action. In order to serve these purposes, a wide swath of the public has to be armed. As George Mason has observed, to disarm the people, that is the best and most effective way to enslave them. Hamilton noted, if the representatives of the people betray their constituents, there is no resource left but the exertion of the original right of self-defense, which is paramount to all positive forms of government. Well, that's pretty aggressive. Federalist 28. I forgot that language completely. Thus, as Patrick Henry concluded, the people must guard with jealous attention the public liberty. Suspect everyone who approaches that jewel. Unfortunately, nothing will preserve it but downright force. Whatever you give up that force, you're inevitably ruined. Well, geez, we're getting really aggressive here, aren't we? The great object is every man be armed. Everyone who is able must have a gun. Madison and other founders often explained how the militia was key to safety and defense. To secure these functions and avoid becoming a standing army, individuals need to be armed. Indeed, one of the advantages Madison thought Americans possess over people of almost every nation was the advantage of being armed, in Federalist 46. In public discourse, Madison contrasted this American advantage of armed citizens with Europe, where governments were afraid to trust the people with arms. For European governments recognized an armed citizenry could not be conquered by the largest standing army that could be supported. That's probably true today, despite what Uncle Joe says, right? Despite what Uncle Joe says, where he threatens to nuke us. The arms and an armed citizenry can do quite a lot against even a standing army. Yeah. If European powers permit an armed citizenry and local governments that appoint militia officers, the throne of every tyrant in Europe would be speedily overturned, in spite of the legions which surround it. For Madison, this combination in America, the advantage of being armed, alongside the existence of subordinate governments in which the people are attached and which by their militia officers are appointed, form a barrier against tyranny. And Constitution provides both advantages to check arbitrary power. Its structure, design, protected local government separate from the federal government, federalism. A Second Amendment protected private citizens' right to keep and bear arms. The civic purpose reflected the right of the people to voluntarily create the state to protect their rights from others. We the people, right? The people collectively come together to form the state for their collective benefit. And one of these rights, however, that's retained is the right of self-defense. The privately armed populace furthered these interconnected rights and duties at the core of the state and the Second Amendment. Defense of oneself and of one's community. So while the individual right of self-defense is a central component of the Second Amendment, the civic purpose was codified based on the fear a tyrannical government would eliminate the civically minded militia. Both reflected pre-existing rights of self-defense the founders valued as core. In the founders' world, individual self-protection and community defense were not wholly separate spheres. The relationship between narrower civic purpose and broader individual right provides us one way to understand the scope of this right. The relationship between... Okay, I already said that. $5 from Mandalore Wise. Now that they mention it, hard to think of another country with such a thoroughly armed populace from inception. Thank you for the super chat. It really, really makes a difference. I really appreciate your super chats and your support. And I appreciate the 181 of you who are currently here to enjoy this stream and listen to some legal analysis where we learn some legal analysis and we discuss the law as it's being modified. I appreciate that you're here. Every one of you is here helps the channel grow. I appreciate it. Thank you. Those excluded from the militia were not excluded from the Second Amendment, but those included in the militia were covered by the Second Amendment. So because the militia is a subset of the people, those in the militia share the rights as the people. With this in mind, we look to militia laws in effect at the time of ratification to determine how the public would understand militia. It's a reasonable place to start. Those who are obliged to serve in the militia and bring their own arms fall unambiguously within the meaning of the people who have the right to keep and bear arms. Men trained to arms from infancy and animated by love of liberty will afford neither cheap or easy conquest. From the Journals of the Continental Congress. Continental Congress's address to the inhabitants of Great Britain in 1775. Okay. This is an interesting quote. So apparently in 1775, the Continental Congress, I guess, passed a resolution or something, and they made an address, like a speech, kind of, to Great Britain. And in the Congress's speech to Great Britain, as it were, they say, /right, men trained to arms from infancy and animated by love of liberty will afford neither cheap nor easy conquest. That's kind of badass. On every possible level. That's kind of cool. Every militia law near the time of ratification required 18-year-olds to be part of the militia and bring their own arms. Around the time the Second Amendment was ratified in 1791, Congress began debating invoking power under militia clause to better organize the militias. The effort was pushed by Secretary of War Henry Knox, who argued Congress that while the military age has commenced at 16, the age for federal militias should be 18. Because youth at 16 do not commonly attain such degree of robust strength as enable them to sustain without injury the hardships of the field. One of the first rejected proposals suggests that the federal government would arm everyone, but this drew sharp rebukes, such as Representative Wadsworth arguing their parents would give them the guns of their own, then take them from others in the U.S., which were liable to be taken away the very moment they were once wanted. So Representative Wadsworth over here in 1770-ish, circa 1770, thinks that one of the duties of a good parent is to give their child a gun. I like that too. Apparently that was said sometime between December 1790 and March of 1791. Okay. The proposal raised concerns that any check on tyranny could be undermined by federal control of militia arms. In the end, Congress settled on the first Militia Act of 1792. The act required each and every able-bodied white male of citizens who was of the age of 18 and under the age of 45 to be enrolled in the militia. The act also required every citizen so enrolled and notified shall within 6 months provide himself with a firearm and ammunition. I don't know. Some of this is kind of, I like this too. This too. One of your duties as Americans, right? This kind of reminds me of some of the stuff Jordan Peterson talks about, where we say, well, we talk a lot about rights, but we don't talk a lot about duty. You know, and implicitly, everyone's rights are also someone else's duty. Now, they might be a negative duty, right? They might be a duty not to do something, but there's still an obligation, right? Everyone's right is someone else's obligation. You know, your rights prevent me from interfering with you. So that is my obligation not to interfere at the most basic, right? So I kind of like this. It's like, well, the Constitution talks about the rights of Americans. Maybe what are the duties? And one of your duties as an American is to go buy a gun and ammo. Praise the Lord and pass the ammunition, man. I'm feeling very pro-America right now. USA, USA, USA. State laws also help us understand the original public meaning of militia because, as Constitution requires, many militias are defined by state law, and those state laws only further prove the point. Before ratification, when militias were solely defined by state laws, most colonies set the age for enlistment at 16. Right after ratification, federal law set it at 18. Every state apparently changed too. Like the Federal Militia Act, these state militias required enrolling citizens, including 18-year-olds, to bring their own firearms and ammunition, either explicitly or as general background principles. I like that. They either said it explicitly or it was so obvious it didn't need to be said. Generally, firearms were owned privately and kept by members of militia in their homes, as the government did not provide or keep guns unless the citizen was too poor to afford one. That's nice. And there's a footnote here, which doesn't really go into any detail, but apparently apparently there was a universal basic firearms care. All right. So apparently, yeah. So while today we argue about universal basic health care and government provided health care, apparently, at least in some parts of the U.S., in 1791-ish, circa, there was universal firearm providing. If you're entitled to a lawyer and a firearm. If you cannot afford one will be provided for you at government expense. Okay. Most of those in the militia are quite young. As a founder wrote, the power of the sword are in the hands of, Yeomanry? There's no way I got even close. Of American from 16 to 60. Their swords are the birthright of Americans. Badass. Because individual right is broader than the Second Amendment civic purpose, those required to serve in the militia and bring arms will most assuredly have been among the people who possessed their rights. And it's indisputable historical evidence that 18-year-olds had joined the militia and bring their firearms. So those 18 and older would have been understood to be covered by this. Yeah. Despite the overwhelming evidence, the federal and state militia laws around the founding required those at 18 to serve in the militia with their own firearm. The government suggests that more specific militia exclusions and requirement undermine these general laws. That doesn't, no. Like, just because there are, again, this is kind of the collective court, collective government understanding of the Second Amendment for some reason, which is bizarre, right? There are exceptions. Therefore, everything is exceptions. The Second Amendment isn't unlimited. Therefore, it's all the limits. In the decades after ratification, several states enacted laws that at times raised the age for service to 21. But even if 18-year-olds were not part of the compulsory militia, they're not necessarily excluded from service. For once again, the militia is but a subset of those within the Second Amendment right. Incidentally, they're talking about state laws here. The Federal Militia Act wasn't amended until sometime in the 20th century, I think, when the National Guard was basically created. Militia laws are helpful because they provide a baseline for determining relevant political community. $5 from Storm Crow 900. UBFP, Universal Basic Firearm Provisions. M16s and 90 rounds of ammunition for the poor. Let's codify it. Militia laws are helpful because they provide a baseline for determining the relevant political community that enjoys the Second Amendment right. They support affirmative conclusion that 18-year-olds are protected by the Second Amendment. No, that's the greatest political compromise of all time. I've solved it, guys. I have solved national politics. I have fixed America. I've solved it. I've solved it. Here's the grand compromise. You ready for this one? You guys should know where this is coming already. The Republicans will agree with the Democrats as to universal basic health care. In exchange for which, I've solved America. USA, USA, USA. Further, the substance and timeline of those failed aid of the government. The law closest to ratification cited by the government was enacted by Pennsylvania in 1793. The law, like all militia laws at founding, required 18-year-olds to join the militia. It only exempted those from 21 from active military service during times of peace. The next closest law to ratification comes from Delaware in 1807. It required 18-year-olds to be enrolled in the militia, only those exempting 21 from duty in peacetime. The remaining laws are decades newer. Even some of those only provide peacetime exemptions. These peacetime exemption laws do not exclude those under 21 from enrolling in the militia. In fact, they often still required 18-year-olds to join the militia. They just exempted those from certain militia requirements during peacetime, such as bringing a firearm. So laws do not undermine, but instead reinforce the conclusion that 18-year-olds were included in the public conception of the militia. As noted previously, because states were not subject to the Bill of Rights, the further one moves from ratification, the more state variation will occur, and less prohibitive the laws will be interpreting the Second Amendment. While we should not completely discount evidence closer to the Civil War, the later militia laws are less instructive. In the decades after the founding, the militia had become much less important while individual self-defense become more meaningful. As a result, fewer people needed to be in the militia, and militias were less tied to gun ownership. So militia laws enacted decades after ratification, especially when militias were in decline, provide limited events of original public meaning of the Second Amendment. The government also relies on 1778 New Jersey law that set the militia age at 21 for a single call to arms. The militia law called for 1,000 men aged 21 and older to enlist themselves to defend the frontier of New Jersey, which is kind of hilarious. The government's reliance on this law reveals the sinking stand on which it stands. The law was a one-time call for arms for a singular purpose. It permits officers to enlist those from 1621, but only calls upon those 21 for this particular service. Moreover, New Jersey still requires 16-year-olds to enroll in the militia. New Jersey, back when New Jersey, was cool, I guess. Both before and after this temporary call to arms. The mandatory enrollment age increased to 18 around ratification and remained there through 1829 when state enacted peacetime exemption laws for those under the age of 21. Taken together, none of these New Jersey laws reflected that 18-year-olds were excluded. The government also points to a series of Virginia laws that set varying ages for militia service. But at the time of ratification, Virginia requires militia service for all men 18 and older. In 1705, Virginia set the age at 16. In 1723, Virginia first raised the mandatory age for enlistment to 21, but made it clear that 16-year-olds could be admitted as substitutes. I wonder what exactly they mean by substitute here. Is this like you can get someone else to serve your militia service for you kind of thing? Virginia kept the minimum age of 21 and used that age of service for a special call for arms in the French and Indian Wars. The next year, however, Virginia adopted 18 as the age of service, then reduced the age to 16 during the Revolutionary War and returned to 18 during ratification. Pennsylvania follows a similar story. In 1755, at the height of the French and Indian Wars, Benjamin Franklin drafted and got passed a militia law that required the enrollment of men over the age of 21. But in 1777, Pennsylvania lowered it to 18, where it remained throughout ratification. There's a little note here about Pennsylvania. A couple notes about Pennsylvania here. Those under 21 could enlist. And an act for the better ordering and regulating such as are willing and desirous to be united for military purposes within this province. Pennsylvanians quickly moved to ask 16-year-olds to voluntarily enroll and imposed a tax on those who did not. This is the Obamacare of its age, right? This is the Obamacare of its age. Instead of being forced to buy health care or pay a tax, you're forced to enroll or in the draft at 16 or pay a tax. I'm seeing possibilities for unification between Republicans and Democrats as we speak here. So the state required enrollment by 18 during decades around ratification, which is critical time for determining the historical meaning. Next, the government points to 3 state laws requiring parental consent to enlist in the militia, but 2 of those states were not states at the founding. That's fun. Yeah, let's point to states that aren't states. And their laws were not passed until 1835 and 1863, which is a little bit after 1791, one would take notice. The earliest of these laws was passed by New York in 1818, but it's a stretch to claim that required parental consents for anyone under 21, as the law required 18-year-olds to enlist in the militia and only required consent to join particular companies, such as the cavalry and artillery. Before ratification, New York set the enlistment age at 16, and right after ratification was raised to 18, in line with the federal law. And even true parental consent laws exempted 18-year-olds from mandatory service in the militia, but permitted them to join with parents' permission. The government also points to a handful of laws requiring parents to furnish arms and pay fees to their enlisted children. This is good shit, right? One of your duties as a parent, you must feed your child. You must provide your child with guns and ammo at your expense. It's one of your duties as a parent. It's one of your duties as Americans. Most of these laws require 18-year-olds to enlist, but do not set an age for parental liability, just requiring guardians to be liable for equipment and food and guns. And the existence of these laws is unsurprising, given some states require those older than 16 to enlist in the militia. Regardless, the point remains that those minors were in the militia and as such were required to provide their own weapons, even if those parents had to buy weapons or consent to them joining. So contrary to government claims, state and federal militia laws show 18-year-olds have the right to keep and bear arms. Near ratification, every state and federal government require the 18-year-old men to be in the militia and have their own weapons, meaning those people were part of the people, protected by the Second Amendment. Nothing in the few and distant militia laws the government identifies undermines this conclusion. Founding-era militia laws require strong evidence that 18-year-olds were covered by the Second Amendment. So to undermine this evidence, the government turns to other historical arguments. This should be good. Mendel or Wise gives me $5 to say, is this footnote density reminding anyone else of the California 2A decision? They have thoughts. Since they know they're going to be overruled, they might as well get out their thoughts clearly, this is going to be taken up by en banc, and the en banc is going to say the words intermediate scrutiny a lot. First, the government contends the Second Amendment is tied to virtue. All right, I just want to read that from the entire start over again because the context got a little lost. Founding era militia laws provide some strong evidence that 18-year-olds were covered by the Second Amendment. So to undermine this evidence, the government turns to other historical arguments. First, the government contends the Second Amendment is tied to virtue, and minors are not considered virtuous. The government thus posits that because the age of majority at the founding was 21, those under 21 are not covered by the Second Amendment, which also implicitly would be true for all the amendments, one would think. Second, it points to state laws in the late 19th and early 20th century that restricted the sale of handguns on the age. We do not find this argument persuasive. Both parties rely on age of majority to make their case, but they look at age of majority from different time periods. Neither is relevant. Plaintiffs argue because the age of majority is now 18, 18-year-olds have Second Amendment rights. In response to the argument, the Fifth Circuit correctly explained, majority or minority is a status, and that lacks content without reference to the right at issue. Fair. Yet inexplicably, the Fifth Circuit, which incidentally went the other way on this issue, so there's a circuit split, so there's that. The Fifth Circuit concluded that 18-year-olds do not have Second Amendment rights because the age of majority was 21. The government likewise relies heavily on this idea that age of majority is 21. But the age of majority at the founding lacks meaning without reference to the right. As Blackstone makes clear, the relevant age of majority depends on the capacity or activity. For example, a man could take an oath at age 12, be capitally punished in criminal cases at age 14, and serve as executor at age 17. And a woman could consent to marriage at 12, choose a guardian at age 14, and serve as an executrix, which is a female executor of an estate, which I always love that IX ending. I'm a bit of a sucker for that. Serve as an executrix for age 17. Both sexes have until the age of 21 ends. So while full age majority is 21, that only mattered for specific activity. And even so, the constitutional rights were not generally tied to the age of majority, as the First and Fourth Amendments applied to minors at the founding as they do today. So the age of majority Blackstone identifies for different activities tells us little about the scope of the Second Amendment. To square the circle, some have attempted to connect the age of majority to the Second Amendment by arguing that the right to keep and bear arms depends on a civic virtue. And those under the age of 18, the founding era majority, were not considered virtuous. But even if a group could categorically be restricted from possessing Second Amendment rights because of a group's perceived virtue, we find the fact that those of 18 or older had to serve in the militia at a time of ratification means that these are not such a group. Even so, any determination of a group's dangerousness fits more appropriately at step 2 of the analysis. The age of majority argument has been proffered at step 1 to contend those historically considered without virtue or outside the scope of the Second Amendment. There's ongoing debate about the relevance of virtue. And then there's a footnote, which I want to read. The sources relied on for the notion that 18-year-olds were not considered virtuous are like layers of a Marcosia doll, each nested layer successively larger with little at its core. These sources merely cite each other without offering primary sources supporting the ideas that minors were considered unvirtuous. Okay. We're having an argument about virtue and its applicability to those under the age of 18. Okay. I wonder what Aristotle has to say about this. Even if virtue matters, there's no founding evidence that 18-20-year-olds were considered unvirtuous, as only the few sources refer to minors, and the ones that do just cite each other, and that's not historical evidence. The cited evidence to support the contention minors could be prevented from buying firearms comes from a passing reference in a footnote in Thomas Cooley's treatise, which was published nearly a century after ratification, which held that a Tennessee law in 1878 made it illegal for someone to sell, loan, or give a minor a pistol except for hunting was valid. Putting aside the limited weight that should be given to a passing statement in a footnote, which is ironic given how many footnotes are here, but whatever, Cooley's lone source is a state case applying state law from decades after ratification. Here the law nor the case carries much value in determining the original public meaning of the Constitution. Moreover, the case cited in Tennessee stands for the proposition the Second Amendment only protects the right to keep and bear arms for common defense in a military context, not an individual right, which of course Heller poo-poos on a lot. Not only did Heller explicitly reject the limited military and collective view of the Second Amendment, but also rejected the case law as offering an odd reading of the right and not one we adopt. So the only primary source the government can muster comes long after ratification does not support the case. And even so, in Cooley's separate discussion of the Second Amendment as an individual, the meaning of the provision undoubtedly is the people from whom the militia must be taken shall have the right to keep and bear arms, and they do not need permission or regulation of law for this purpose. Nice. So if anything, Cooley's perspective on the Second Amendment reinforces our conclusion. Those who were in the militia had the ratification, had their own militia. The idea that 18 to 20-year-olds are not virtuous in the same manner as felons is a strange contention. Why would the federal government in every state require unvirtuous people to have guns and be in the militia? Even if being unvirtuous means you can and probably should be disarmed. It's also odd considering this group has most other rights, which at least some of those rights are circumscribed for felons. As a result, the government argument fails to persuade us that 18 and 20-year-olds were considered unvirtuous, like felons, and thus outside the Second Amendment. Failing to find purchase in founding era militia laws or the age of majority, the government turns to historical regulation. While some gun regulation existed at the founding, there were no regulations restricting minors' ability to possess or purchase weapons until two states adopted such laws in 1856. The Fifth Circuit relied on the prevalence of gun use or gun control has been inextricably intertwined, and restrictions on that group were also allowed. Ironically, I just realized how long this opinion was. I'm going to need to get up and get something to drink because I cannot keep going. I was waiting for the end, and we're not even close. All right, let me come to the next bullet point, and maybe we'll stop and we'll do part two, because this is just for reference. I'm not sure where the majority opinion stops and the dissent begins, so I'm not sure how long the principal opinion is, but I'll take note that I'm on page 55 of 141. So, yeah. So I guess we can have a vote, or it'll just depend on my energy level as to whether we can keep going or not. The government offers a long list of state laws that set various ages for purchasing or possessing guns. Instead, this list reveals that nearly a time of ratification in those laws restricting the sale of firearms to 18-year-olds. The earliest laws were passed over 16 years after ratification, and most were enacted after the Civil War. According to the government, by the end of the 19th century, 18 states and D.C. in some way restricted the right of gun ownership to those at 21. This is less than half the states admitted by 1899. Only 5 states in D.C. expressly restricted gun ownership to those under 21. The rest, the government argues, restricted gun ownership of minors, and those under 21 were considered minors. But the 19th century cases are typically cited to support such restrictions. Either do not deal with the issue, apply to those only the age of 18, do not address constitutional concerns, or rely on logic rejected by Heller. By the early 1920s, another state expressly restricted gun ownership by those under the age of 21, while 2 others did so by implication, bringing grand total to 21 states and D.C. So even if we consider laws from more than a century after the founding era, a majority of states, 27, do not seem to have been restricted 18-year-olds from purchasing or possessing handguns. They instead restricted younger people. In fact, the cited 1868 Oregon law affirmatively protects the gun rights of those over the age of 16. All right, so I'm at the page of start at page 59. Let's see how long this goes on. '83. So on page 59, and it ends at page 83. And then there's some appendix, and then there's a dissent from Judge Wynn. All right. I need a water, or I need a soda or something. So, but we will get through this together with your super chats. Okay. All right. Let me get a soda. Talk amongst yourselves. Or water or something. Talk amongst yourselves. Part to it. Stephanie says the part to it. Okay, we'll part to it then. We'll part to it then. And that way we can maybe cover the dissent too. So we'll part to it. I think. That makes sense. That makes sense. All right. I think we'll part to it. Well, this went on for a long time, and we're enjoying this, but we will pick it up next time. And we're an hour and a half into this. This is a long time. Excuse me. This is going on a long time, and we'll part to it. We'll pick up pages 59 through 83 next time, and we might cover the dissent. Yeah. So I'll just take a couple. Just go with OT. I don't know what OT is. I just go with it. You mean? The people want it? Okay, so just finish it then? All right, fine. We'll finish it then. Okay. All right, we'll finish it then. We'll finish it then. Okay. Okay. Okay, let's pick up. Now that we've had some refreshing water. As explained earlier, we focus on the historical inquiry in step 1 on the time of ratification of 1791. At the time of ratification, there were no laws restricting minors' possession or purchase of firearms. Most laws affecting minors postdate the Civil War, and only 2 states to pass such laws before the Civil War did so immediately before the war, over 60 years after ratification. The laws from the later time periods provide little insight into the amendment's original public meaning. Yeah, if you're trying to figure out what the Second Amendment meant in 1791, looking to the Civil War, 1860, not particularly informative. Yeah, and I do have a patch room. I do have 150 people here. That's true. And we do try to serve the people when we can. Laws that were passed by states were not bound by the Second Amendment. That's true at the time, too, because the Second Amendment didn't apply, so that's even less informative. It'd also be strange to rely on 2 Southern laws restricting gun rights that were enacted before the Civil War, given Congress's grave concerns about Southern states disarming free blacks for this period. Yeah, so looking to the laws Southern states passed restricting rights is a little odd since, the federal government was concerned about exactly this. State law passed decades after ratification restricting gun ownership at a time when state laws used to disarm groups is weak evidence of the original scope of the Second Amendment. A review of the Constitution's text, structure, and history reveals that 18-year-olds are covered by the Second Amendment. Like most other constitutional rights, the Second Amendment has no explicit age limit, and the most analogous rights apply to everyone. And when a constitutional right applies differently to minors, the age cutoff has been consistently at 18, not 21. Founding era history confirms the public understood the Second Amendment to cover 18-year-olds. At the time of ratification, every state and federal government required 18-year-olds to enroll in the militia. Those in the militia, as Heller reminds us, were a subset of the community known as the people that enjoyed the Second Amendment right, like all the rights. While most of the militia laws the government identifies still allow 18-year-olds to join the militia, those that require enlistees to be 21 are far fewer in number and distant from time. So historical basis for 18 and older having Second Amendment rights were less on firmer ground. I just would like to note this is way more historical analysis and actual consideration of the contemporary meaning of the Second Amendment than I'm used to seeing in Second Amendment cases in general. I think I've said this a couple times at this point, but normally in these cases, you just see the words intermediate scrutiny repeated a lot. The government has a substantial government interest because guns are bad and violent. And, this is reasonably related to that. So yay, right? There's not really a lot of analysis of history. But this is the kind of thing that you're looking at, right? Especially if you're an originalist or a textualist. Either one, right? You want to know what the right to keep and bear arms meant at the time. Right? That's a good question. What did the freedom of speech mean? What did the right to keep and bear arms mean? These are good things. We know that not everything spoken is within the freedom of speech. Defamation, slander, fighting words, true threats. So just because it's spoken doesn't mean it's necessarily covered by the First Amendment. Even where it is covered with the First Amendment, we have all kinds of analysis. And that analysis is strongly informed by the history that preceded the adoption of the First Amendment, because it's the freedom of speech, the pre-existing one. So, if you're trying to figure out what kind of speech is within freedom of speech, or trying to figure out what kind of arms are within freedom of arms, and trying to figure out what kind of regulations, restrictions, boundaries, caveats are applicable, this is kind of like what you want to do as an originalist. I read this and it goes to my originalist heart, because we're going through a historical analysis. Let's look at the contemporary sources. How did they treat 18 to 21-year-olds when it came to guns? Good question. And the court has done their homework. And it's persuasive for it. Right? It's persuasive for it. And so instead of just saying, well, intermediate scrutiny a lot and, guns are dangerous and they need to be regulated and, not really doing this deep dive analysis stuff on the history of what they were talking about when they wrote the right to keep and bear arms. What was that? What arms were they talking about? What does keep mean? What does bear mean? What are the limitations of that? Who does it apply to and when and what circumstances and so forth? This is how you answer that kind of question, which is decidedly missing in many courts of appeal decisions, it seems to me. Good. Not only has the government failed to carry its burden to show regulated conduct was outside the Second Amendment scope, but the Constitution's text, structure, and history affirmatively prove that 18-year-olds are covered by the Second Amendment. Having found that 18-year-olds are protected by the Second Amendment, our precedent requires that we apply an appropriate force of scrutiny. And this is normally where we just say intermediate scrutiny a lot if we hadn't already got there. The Second Amendment's core protections the right of law-abiding, responsible citizens to use arms in defense of hearth and home. When that right is severely burdened, which, not having a gun at all, we apply a demanding strict scrutiny test, but the right only is burned by the margins, intermediate scrutiny. Because we find the law do not even pass intermediate scrutiny, we need not decide how close to the core of the Second Amendment. So this is the more modern approach that some of these courts are doing now. That the ones that are actually upholding the Second Amendment, right? So they're the ones that are actually upholding the Second Amendment aren't really trying to argue for strict scrutiny anymore. What they're doing instead is just insulting all the courts and being like, yeah, they don't even pass strict intermediate scrutiny, which is actually more effective and more hilarious. Right? So it's not a battle between we say intermediate scrutiny and we say strict scrutiny. It's a battle between we say intermediate scrutiny and we say that you can't even do intermediate scrutiny right, you idiots. I find that more persuasive and entertaining. Intermediate scrutiny requires the government to show a reasonable fit between challenge regulation and substantial objective. This reasonable fit language is not the way that I know the test. That's for damn sure. So I'm not sure which case they're citing, but that doesn't sound right. It sounds like a misquote. Or someone made a mistake. When normally you're talking about reasonableness, you're talking even talking about rational basis. Right? Anything makes sense. Various evidence can be mustered to meet the standard, but reference to legislative findings, academic studies, and other empirical data is necessary. And while case law, even common sense may be relied on, the government may not rely on mere anecdote and supposition. The government must therefore offer more than speculation to connect a ban on 18 to 20-year-olds purchasing handguns from licensed dealers, incidentally, to a substantial interest. To begin, the government's interest in preventing crime, enhancing public safety, and reducing gun violence are not only substantial, but compelling. Thus, we look to where the regulations are a reasonable fit, which is why this language is not correct, but we're going to use it and we're going to get there anyway, which is kind of nice. At the summary judgment stage, the government only proffered evidence from the congressional record to support finding a reasonable fit between compelling interests and challenge laws. Before the district court, amici offered a more contemporary evidence to address this analysis. The government, however, neither adopted nor relies on it. So it's unclear whether we may rely on amici's evidence on appeal. But if we did consider amici's evidence, it does not change our analysis, for amici merely offered contemporary evidence to reinforce the congressional record, and evidence does not alter or remedy the flaws. The basic logic of the argument is this. Okay, this is good. The brains of those under the age of 25 are not fully developed, so those individuals are prone to reckless and emotional behavior. Because of this underdevelopment, youth, especially those 18 to 20, commit a disproportionate amount of violence, Handguns are the main tool used to commit the violence, and many of the handguns are bought from licensed dealers. So restricting the avenue of purchase for the age group will reduce crime. I have to say that's not the most logical set of reasoning I've ever heard in my life. Amici then tried to tie a bow on all this by arguing the passage of state gun laws has coincided with decrease in youth suicides and unintentional deaths. Whatever the credence these contentions may have, we find the chain of logic suffers from two debilitating flaws. A show of disproportionate bad conduct by a group cannot justify categorical restrictions on right when a percentage of the group engaged in the unwanted conduct is minuscule. And the evidence does not sufficiently link purchases from licensed youth to crimes committed by youth. You know, I'm just going to take a flyer. I'm going to take a flyer and I'm going to assume that the youth buying guns from licensed dealers is not a major source in gang-related crime. Just, gonna take a guess. The Supreme Court guides our analysis. In the first case, without intermediate scrutiny, in a case that was argued excellently, incidentally, by then attorney Ruth Bader Ginsburg, the court held an Oklahoma law that prohibited licensed sellers from selling, bartering, or giving low alcohol beer to males under the age of 21 and females under the age of 18 because they could not show sex classification was substantially related to road safety. The court reviewed studies that showed 18, 19, and 20-year-old males were disproportionately arrested for, killed by, and injured by drunk driving. The court accepted that only 0.18% of females compared to 2% of males had been arrested for drunk driving, but it rejected this evidence as sufficient to satisfy intermediate scrutiny. If maleness is to serve as a proxy for drinking and driving, a correlation of 2% must be considered an unduly tenuous fit. The court also found significant the state did not measure the use and dangerousness of 3.2% beer, as opposed to alcohol generally, to tie the challenge restrictions to interest in reduced driving. So in total, the state's evidence did not satisfy the courts that sex represented a legitimate, accurate proxy for the regulation of drinking and driving. The same flaws plague the evidence here. First, while 18 to 20-year-olds commit disproportionate amount of crime compared to other age groups, very few members of the group commit crime, making correlation between age and guns unduly tenuous. Second, like the connection between low alcohol beer and drunk driving, this is something I would never have thought to connect in my mind. I don't necessarily dislike the analogy. It just would never occur to me. So I guess this is an opportunity for me at a minimum to learn something. It would never occur to me to compare the fact that while 18 to 20-year-olds commit crime more than other ages, most people in the group don't commit crime in the same way that most people who drank 3.2% beer in 1970 and so forth and so on. I never would have thought to connect. I wonder if there's any sort of subtle burn here that's intended. And maybe this is reading way too much into it. It probably is. This is probably reading way too much into it. I wonder if there's any subtle burn here, because that case dealing with the 3.2% alcohol was argued by then attorney Ruth Bader Ginsburg. So I wonder if there's some sort of subtle burn here that's basically saying in so many words, we're adopting the argument that Ruth Bader Ginsburg made to uphold gun rights. Is that reading too much into it? We're upholding the argument Ruth Bader Ginsburg made to uphold gun rights. Is that reading too much into what's going on here? Maybe. Yeah. It's an interesting note. Yeah, they're not citing Ruth Bader. They're not citing Ruth Bader Ginsburg. They never mention her. It's just that she argued this case. So I'm just wondering if there's like, so they never mention it, but it's just like, this is the argument Ruth Bader Ginsburg made. And we're going to adopt that argument. I don't know. Reading too much into it? Probably. Laws at issue here rest on the premise that young adults' Second Amendment rights can be limited because they're responsible for a disproportionate amount of violent crime. But these laws over-inclusively restrict the rights of a large group of law-abiding citizens to target a tiny percentage of them. In 1967, Congress was concerned about a disproportionate increase in crimes committed by youth. But the disproportionate rate of crime committed by this group tells us nothing about the percentage of the group that commits crime. McKay's contemporary sources purport to show that 18, 19, 20-year-olds make up 4% of the population but account for 9.4% of violent crimes. So while 18 to 20-year-olds may commit a disproportionate share of violent crime, an exceedingly small percentage, around 0.3%, and definitely less than 1%, of the 13 million young adults in this group commit crimes. So yeah, it's while they make up 4% of the population, and while they account for 9.4% of the violent crimes, of the entire population, only 0.3% are committing those crimes. This alone cannot justify restricting the entire group's rights. What's more, those calculations do not account for repeat offenders. In fact, a year after being released, over 40% of criminals are arrested again, and that number approaches 80% in the 6 years after release. This means an even smaller percentage of the group is likely responsible for disproportionate crime. Yeah. So of the 0.3%, right, 40% are like, 40% of those are repeat offenders. So that means roughly like 0.15% are not, or okay. But beyond overbreadth, consider the implications of this argument. Men commit disproportionately more violent crime than women. Does that mean the Second Amendment rights of men can be categorically restricted? Treating sexes differently would also receive intermediate scrutiny, so why not? A similar argument could be treated for any number of groups, such as those living in specific geographic locations, arguing that because crime is higher in urban centers, more restrictions are allowed. Amicus' own evidence and arguments would support restricting 21 to 25-year-olds' rights, if not older adults, as much as it supports drawing the line 21. And if that's acceptable, and if so, where's the line? Craig also explains why such laws would fail when declared that a correlation of 2% must be considered an unduly tenuous fit. The question is not about disparity of groups or total crime, but the percentage of groups that use gun in an impermissible manner. The statistic gives us some insight in the likelihood that any one person in the group will use a gun improperly. Whatever the precise answer to that question here falls well below the tenuous threshold from Craig. So yeah, and Craig apparently it was 2% of men who were getting into drunk driving or something like that. And we're talking about 0.3%. So 0.3 is less than 2. So yeah. Stephanie asks if I'm more dangerous with a firearm than her. Probably not. Probably not. The rights of more than 99% of a group cannot be restricted because a fraction of the 1% commits a disproportionate amount of violent crime. And while it's already illegal for felons, fugitive, drug users, and aliens unlawful in the United States, among others, to buy firearms from licensed dealers, so laws at issue by their nature prevent more law-abiding, less dangerous subset of 18 to 20-year-olds from purchasing a more regulated market. For reducing gun violence and crime, restricting a whole group that is almost entirely law-abiding is the definition of an unduly tenuous fit. And because those who are young also disproportionately the victims of crime, preventing them from purchasing handguns implicates their self-defense. That's actually a really nice point. That's a really nice point, and one that shouldn't go by the wayside, right? So young people might be committing more crimes, but they tend to go after their own, like most criminals do, right? Yeah. So in the same way that that young people may be the most active, they're also the most likely to be victimized. So yeah, that's nice. The irony does not escape us under the government's reasoning. The same 18 to 20-year-old men and women who we depend on to protect us in the armed forces and have since our founding been trusted with the most sophisticated weaponry should nonetheless be prohibited from purchasing a handgun from an FFL for their own protection at the home. Yeah, that's funny. I don't know if there's any 18 to 20-year-old Minutemen out there, but it would be particularly ironic if there are, right? We trust you with the nuclear weapons, but not so much buying a handgun. The second major flaw at issue with these is licensed dealers whose sales 18 to 20-year-olds are the subject of challenge regulations are not connected to the incident of crime Congress sought to control. It's not enough to target guns generally, argued less access to guns means less crime, as that would justify almost any restriction and eviscerate the Second Amendment. In Craig, the government could not merely contend access to alcohol generally led to drunk driving by men to justify a sex-based restriction. I mean, we're really, really leaning on this Craig analogy. So someone is very pleased with themselves in the court over this analogy. We've spent quite a lot of ink at this point just talking about Craig. How was the sale of 3.2% beer like the sale of firearms? The answer will surprise you. The government needs to connect the low alcohol beer to drunk driving to justify the disparate treatment. So too here, access to guns through licensed dealers rather than access to handguns must be sufficiently connected to 18 to 20-year-olds' use of firearms to commit violence. If the congressional record nor amicus evidence can draw this connection, further undermining any claim to a reasonable fit. In its Congress's findings, Congress concluded that concealable firearms have been widely sold by federal dealers to emotionally immature or thrill-bent juveniles and minors prone to criminal behavior, which caused an increase of crime. The basis for that conclusion appears to be a hearing of IRS commissioner. Again, how's the IRS get involved in this? During one hearing, the commissioner of the IRS stated that the vast majority, in fact, almost all the firearms, are put into the hands of juveniles by importers, manufacturers, and dealers who operate under FFLs. How's the IRS involved in this? The government and amici rely on the statement to connect guns from licensed dealers to crimes, but there's several problems with this line of reasoning. First, the IRS testimony notes that almost all firearms in the hands of minors, not almost all guns used by minors, came from licensed dealers. Cohen only discussed access to firearms generally, which tells us little about the connection between guns minors bought from dealers and guns minors used in crimes. Second, his testimony could be read to make the point that almost all the firearms have at some point come from an FFL, even if indirectly. The fact, while true, does little to show the regulations are reasonable. Most guns at some point come from a manufacturer, and where they're later sold on the black market. So read, the statement provides no support for the link. So reading this statement is far too broad to tell us anything meaningful. The only way the IRS's statements could support this link is if he meant almost all firearms that are used by minors to commit crimes were directly sold by those minors. But nothing in the record says that, and the IRS statements fall considerably short of supporting that. To begin with, while the IRS regulates licensed dealers, do they? Does the IRS regulate FFLs? I mean, I would have thought that would be the ATF. The IRS regulates dealers? Okay. While the IRS regulated licensed dealers, IRS, yeah, I know about the tax stamp thing, but even that goes through the Even that goes through the ATF, doesn't it? Not the IRS. His not enforcement did not know what experience guns were used from and presented no studies or expertise. The IRS cites studies and experience of law enforcement support many of the statements, but are brief and conclusory in contention that almost all the guns in the hands of minors came from licensed dealers. The IRS was in charge, not the ATF? Maybe that's what's going on. In 1965? Okay. Yeah, no, that could be it. Yeah. Yeah, okay. So when was the ATF created? Hold on. 1972. Okay. Well, all right. So that solves that problem. So yeah, the ATF didn't exist yet. Okay. Mystery solved. Mystery solved. Yeah, okay. The ATF didn't exist yet. The ATF didn't exist till 1972. Okay. So apparently in 1965, this was being done by the IRS. Okay. Well, we've all learned something collectively, I guess. Okay. It's true we sometimes give weight to Congress's predictive judgment under the law. But this does not mean we should blindly abdicate our obligation to review Congress's action under heightened scrutiny. Indeed, as we made clear, our obligation is simply to assure that in formulating our judgments, the legislature has drawn reasonable inferences based on substantial evidence. As Turner explained, deference afforded to legislative findings does not foreclose our judgment bearing on the facts of a constitutional issue. Congress's conclusion depends on the IRS's testimony, which itself is conclusory and provides no evidence. But the government must supply actual reliable evidence such as empirical studies, not mere speculation, even if facially reasonable. Yet the government offers to connect licensed dealers to young adult crime is a conclusory finding by Congress based on a conclusory statement from someone who's not an expert in this issue. That is not substantial evidence and is not entitled to deference. Congress may not pass intermediate scrutiny by relying on unsupported conclusory testimony to justify its desired outcome. As statements are merely conclusory, they're owed no special difference lest we edge perilously close to rational basis, which, again, many courts of appeal are doing. Further, one of the contemporary studies provided by Amici affirmatively undermines this connection between handguns bought from licensed dealers and violent crime. The study reflects self-reporting from 253 inmates convicted of offenses. Of those inmates, 13.4% claimed to have bought a firearm used to commit the crime from a gun store or pawn shop, which I would take note is like 87% who say they didn't. And only 11.8% of inmates said they obtained the gun legally. But unlike another study conducted of justice, the study does not appear to account for whether the reported gun store or pawn shop was licensed or whether the purchase was made in the inmate's own name. Justice statistics suggest that 1.9% of all prisoners possessing a firearm bought it from a retailer, and 7 to 8% of inmates who possessed a firearm during their offense brought the gun under their own name from a licensed dealer, while 1 to 2% used another name at a licensed dealer, and 1 to 2% bought a gun from an unlicensed seller at a retail source. Okay. As a result, very few inmates of any age bought firearms used as licensed dealers, much less legally. Yeah. Both studies undermine the IRS's claim that the vast majority, in fact all firearms in the hands of minors, came from licensed dealers. Instead, the studies show that few guns used in crimes come from licensed dealers, and those guns are rarely transferred from a dealer directly to the criminal. The majority come from family and friends, the black market, the street, or some other unlicensed source. The IRS's statement is already insufficient to support the connection, and these studies show that the contentions do not have legs to stand on. The defect raises an under-inclusivity problem. While under-inclusivity matters much less than over-inclusivity, as Congress does not have to combat every facet of a problem, a law that so under-inclusively addresses the government's interests by targeting one of the least problematic avenues of purchasing a handgun raises serious questions about whether the law actually furthers that interest. Yeah, it's a very... While the Congress doesn't have to go after every part of the problem, it's like, this is such a small part of the problem, it's a very weird place to start. For example, in another case, the Supreme Court found a restriction on sharing prescriber information was too narrow to further the interest of physician confidentiality because it allowed the information to be given to anyone, not for marketing. So it's like, it's a little bit weird because, like, you want confidentiality, but it can be done for any reason except marketing. So it's like not a lot of confidentiality. The law noted a broader, more coherent policy might withstand scrutiny, but the narrowness of the law burned right without meaningfully furthering the government's interest. This is the same here. At most, amici studies suggest that 11.8% of inmates who use guns to commit crimes bought them legally from licensed dealers. But even closing off access to licensed dealers does not mean that 11.8% would no longer obtain guns, as they would probably go to unregulated markets, like most other criminals without a background check or other safety measures. So, yeah, 12% of inmates apparently bought their guns from a licensed source, but that doesn't mean that they would just give up. They just go where the other criminals go, the other 88%. In fact, the study itself concludes that criminals avoid the gun market of licensed sellers and prefer unregulated markets. Well, geez. We definitely needed a study to tell you that. You guys ready for that shocker? Were you guys ready for that shocker? Apparently the study shows that criminals tend to avoid the regulated gun market of licensed sellers, and criminals tend to prefer the largely unregulated market involving unlicensed sellers. Well, geez. Who saw that one coming? All of our preconceptions have been shattered. The regulation of firearms sales by unlicensed sellers is likely to be significantly limit the government's ability to keep firearms. 20% of inmates who could legally purchase a firearm chose that avenue rather than a more clandestine route. Okay, so 11.8% of inmates bought their gun from a licensed source. That's all inmates. But not all of them were able to, right? Because some of them were prohibited. So how about the ones who could? Well, apparently, of the ones who were able to buy a firearm legally, only 20% went with the legal option. Even though they could have gone into a gun store and bought a firearm, 80% of them said, I don't want to go on that. I don't want to do that. I want to buy my gun on the black market. Geez, who could have saw that coming? Even aside from the IRS's testimony, these studies undermine an argument there's a connection between dealers and firearms used in crime. This is especially true for otherwise legally purchased firearms, which is exactly what the law bans for 18 to 20-year-olds. But I'm sure that, I'm sure, guys, because, it turns out that 88% of all criminals buy their guns from non-licensed sources. And even 80% of the people who could buy it from a licensed source choose not to. But I'm sure if we had a universal background check, those criminals would be thwarted. Yeah. I'm sure if we had a universal background check, because, hey, of the criminals who could go through the background check legally and pass, only 20% do. So how about that other 80%? Well, surely if we had a universal background check. Let's see. We relied on an amicus study to conclude the very few offenders who purchased a weapon from an FFL, in large part because of the background check requirement, even though most of them could pass it. Or, no, that's the wrong way to phrase it. Even the ones who could pass it didn't. Or didn't do it. Upheld a licensing regime in part because the government established that pushing buyers into a regulated market reduced crime. Because the regulated market requires background checks, tracking, and oversight. The government here wants to push the 18 to 20-year-olds away from this into the unregulated market. Yeah. Congress justified these restrictions to increase parental oversight of firearm purchases of handguns to reduce youth criminality, but Congress and the government have no evidence that parental oversight is effective, much less preferable to that provided by licensed dealers. True. In fact, Congress went to pains to assure the country that minors could still have various guns and possess handguns through other means. And the ban perversely assures that when such young adults obtain handguns, they do not do so through an FFL where the background check is required, but, somewhere else. The laws leave use with three options: receive the gun as a gift from the parents or others, buy it privately, or obtain it illegally. This incentivizes young adults to get the guns in less regulated ways, all without assuring parental input or a background check, because none of those options would allow for a background check. Finally, it's unclear whether these laws have been effective at all. No. While we recognize it would be difficult to determine the effectiveness of these laws now, Congress could have considered the effectiveness of similar state laws before passing its version. In fact, one study found these laws did not influence youth crime. You don't say. You don't say. The studies show a decrease in youth suicides and accidents after the 1994 crime bill that in part banned firearm possession for those under 18. But, it doesn't do anything with the 18 to 20-year-olds. It's hard to draw any conclusions of the effect of a handgun purchase ban from this narrow study of a broader ban. The study admits the state laws that prohibit handgun possession for those of a certain age have been not effective. The study tells us nothing about crime and very little about the cause of decrease in suicides, and admits there are many other gun control regulations that could have been causes. At best, amici studies show potential correlation between one part of a law and fewer suicides and accidental deaths. And the share of violent crimes arrests among 18 to 20-year-old group has increased, and the use of groups by that gun has been disproportionately high. Neither the gun nor amici can show the burden challenged laws imposed on the two. And even if I did, I wouldn't spend basically, 6, 7, 8 pages on it. This, it's an okay analogy. It's just, I would never think to put those two things together. So, okay. Yeah. You have to at least wonder if there's something being said beyond what's being said when you spend that much time on it and that much verbiage on it. Is there a reason other than the obvious? Or let's rephrase that. Is there a reason other than the surface reason to spend this much time talking about Craig in this context? Right? So there's some analogy there to be had. There's, it's okay. I get it. I get it on a surface level. I understand it. But I wonder if we're trying to send a message to somebody. I wonder if we're spending so much time on it because we're trying to poke at somebody we're trying to poke at someone, like, because someone we're trying to talk to really, really believes in Craig. And we're trying to, like, poke at them or make it uncomfortable for them, or we might be writing for somebody who's not obvious. I'm not sure who that is. But I can't help wondering if there's an audience here that's not obvious. Yeah. Those with good faith on both sides of the gun debate wish to protect lives and uphold individual rights. We appreciate the seriousness of gun violence in this country and applaud Congress's laudable desires to curb senseless violence. But we also recognize the Second Amendment embodies a fundamental, pre-existing right that enables the people to preserve their own life, liberty, and property. Striking a balance between those interests is a difficult exercise that draws intense passion on both sides, and it's for good reason. But while Congress or judges may have struck a different balance long after ratification, that role is foreclosed to us by the balance the founders chose. We cannot now second guess or undermine that choice. History has made clear that 18 to 20-year-olds were understood to fall within the Second Amendment protection. Those over 18 were universally required to be part of the militia near ratification, proving they were considered to be part of the people who enjoyed Second Amendment rights, and most other constitutional rights apply to this group. And Congress may not restrict the rights of an entire group of law-abiding adults because a minuscule portion of that group commits a disproportionate amount of gun violence. Congress's failure to connect handgun purchases from licensed dealers to youth gun violence only serves to highlight the law's unduly tenuous fit with these interests. 18 to 20-year-olds have a Second Amendment right, and challenged laws impermissibly burn that right. As a result, we vacate the district court, reverse judgment, and remand for further proceedings. Thus, bringing us to the end of the opinion, which we have now successfully finished together. Focus is a little off. It's autofocus, so what can you do? Is the focus off? I'm right in the center of the frame. I was playing with the camera settings to see if I could get it any sharper. So, Guns Part 2 tomorrow? I don't know. Tomorrow? I don't know. Maybe. We'll see. Yeah. It's out of focus, is it? Looks more like low resolution. I could play with the camera settings a little bit. The logo's pixelated. Well, if the logo's pixelated, obviously that's not a focus issue. Yeah, that's not a picture issue. Could there be moisture on the lens? Maybe. Let's take a look. Yeah, it's a streaming issue. Yeah, I was playing with the settings to see if I could get the image to be any sharper. I'm not sure if it made any difference or not. But I was playing with it to see if I could get the image to be any sharper. So, anyways, I'm going to sign off. I'll play with the settings more, I guess, later. If you're enjoying the stream, please remember to give it a like. Remember to hit the notification bell. If you're not subscribed already, I hope today I earned your subscription. Powered through for you. I hope all's well. Till later, my friends. Cheers. And good night.